Hi, everyone. Thank you for joining us live. We're going to give it a few minutes before we start the Q&A session regarding these latest updates that are coming out. I think, again, giving it a few minutes. Thank you for joining. Here again with a live stream. I think maybe some of you have seen me on live streams before when it comes to dropping news. Yeah, I see the first question that's coming up is how screwed we are in a nutshell. Well, I will get to that. I think a lot of the times when I see a lot of news like this, the first thing that I want to say to every single one of you is please don't panic immediately, right? I think what we learned a lot from the 100K fee scenario was that a lot changed very quickly, even a few days afterwards to a week afterwards, all the way until now. You know, it's a completely different scenario. We recall that during the 100K fee drop, it was annual fees. It's going to be $300,000 for every 3 years. It's going to apply to everybody, anyone, renewals, everything. And here we are today, where at the end of it all, only 80 people have paid for the 100K fee so far. So I think before we kind of jump into it, I have to remind every single one of you that whenever a lot of news like this drops, as much as I can give very general guidance, it is very much a case-by-case scenario. And I will explain on this live stream why that is the case, right? There is no method of perfection in this scenario because there is a lot of lacking, let's call it substance, behind the memo at the moment, right? So I think let's just start first, as many of you are kind of creeping in on what happened, right? So we got some guidance that came out. It's not a fun one. It's a policy memorandum. Essentially, the government addressed to the room, let's call it, to the general public, and also to affected individuals within their agency that, hey, we're going to enforce discretionary policies, right? I want to make it clear that there was no change in the law. There wasn't like a change. They weren't sitting there saying that we're going to change all of the legal frameworks out there. We're just going to affirm the fact that green card applications in terms of adjustment of statuses are discretionary. They're not meant to be automated processes. They're not meant to be administrative. That this whole entire scenario was meant to be, for adjustment of statuses in particular, a discretionary finding. There needed to be like a fundamental base reason for why you are AOSing at this time. And I think to further expound on that, what they were really highlighting, right, and the common thread that I was seeing throughout this policy memo was the fact that they were concerned about individuals who were coming in perhaps on single intent visas, right? You came in on an F1. You told the government that you were intending to return to your home country at the end of this F1 stay, but ultimately decided to file an adjustment of status. And now they really want an answer to that question of why, right? Why are you seeking this adjustment of status in the US? Why are you not going through the normal quote unquote process of consular processing these cases instead? So that is kind of the genuine question that is being focused on, especially for single intent individuals. And I think more pressingly, right, and I think this was my first gut reaction when I was looking at this memo, is the fact that they were kind of highlighting, what if you were here on a B1, B2? You entered the United States on a visitor visa, you met the love of your life, and then you intended to essentially get married, and then you filed for your adjustment because you were married to the love of your life who happens to be a US citizen. It seems like that is, to me, a good focal point of what this memo is trying to really attack. Because at the end of the day, when you enter on a B1, B2, you're supposed to only be here temporarily, but all of a sudden you are seeking this adjustment of status domestically in the United States, right? So there are a couple other footnotes here. I think there's two parts to this memo that I think I want to clearly emphasize to all of you before I go into the Q&A, right? Which is that the government threshold that they're imposing now is this concept of extraordinary circumstances. So if you are seeking an adjustment of status from some of these single intent visas, or like you're saying you're here on ESTA, again, married the love of your life, then the government is allowed to say, what were the extraordinary circumstances or the extenuating situation that requires you to adjudicate this here in the United States instead of going back to your home country and doing it, quote unquote, the proper way. Consular processing, or let's say you came into the United States on B1, B2 instead of a K1. Why didn't you do the K1 process instead? So that's kind of one part of it. The second part of it, and this is a little bit more of a strong footnote for individuals who are already on dual intent visas. You're here on an H-1B, you're here on an L-1. Traditionally, it's okay for you to have the intention to permanently immigrate. The footnote that the government added for those dual intent visas is, hey, reminder that this is not an automatic process. Do not make the presumption that you're supposed to be granting these AOSs just because someone is on dual intent. Let's unearth the underlying things, right? Number one is that, were there any prior overstays or issues, right, before the H-1B? I think one thing to consider is criminality. There are certain amounts of criminality that has basically very little impact to your ability to get an H-1B, but that is a totally different question on the adjustment of status phase. Right? So that's where it comes into these concepts of even good moral character, or in situations where you're trying to express to the government that there's some level of merit, right? That not only are you technically qualified for the green card because you met the requirements, whether it was through a perm process or through an EB-2 and IW, but do you have the merit, right, to qualify for that particular basis? That's number one. Number two is also this question regarding, especially for these dual intent visas, whether or not, right, there is an issue maybe with a status gap in the past, right? I want to express to a lot of you, maybe some of you have heard of 245K. It's this automatic waiver that if you had a gap of less than 180 days or a violation, the government's supposed to technically overlook that in exchange for the employment-based petition for the adjustment. I feel that the government is saying, please weigh the circumstances before you grant the 485, even if they qualify for that waiver. So I think that was like a really solid general primer, right? So I'm going to start with some of the questions that are kind of streaming in from the comments, and then we can go from there, right? I think it's funny to just show this one is how screwed are we in a nutshell, right? Again, I think there's layers to this. The biggest point that I have to give to all of you, and something that we heard a lot from our government advisors and the people that we talk to who still have some certain touch points out there with the government, is that they're really surprised at the rollout of this, right? We have former USCIS counsel on our group here, and a lot of what was being said is that it's interesting that this policy memo was rolled out without updates to the actual policy manual, right? To explain the difference, a policy memorandum is a call out by the government that, hey, we're memorializing, right, a policy change of some format or new sets of policy, right, or an interpretation. Naturally, what comes from that is an update to the manual and the guidance that the USCIS officers and related agencies use when they open up the book to make those adjudications and judgment calls. Traditionally, those are supposed to go hand in hand. They release the memo, they release that manual update. That didn't happen. So weirdly enough, when we look at this memo, there's not a lot of substance other than for us to just interpret what could be happening on the ground. And I think one thing you can note from the memo as well is that they're saying, we're going to roll out guidance based on specific case types and visas, right? So what this means is that this is kind of like the start. We're going to see a lot more perhaps in the future. I can say pretty reasonably well that I do think that this has come a little bit as a surprise. I don't think it was as strongly anticipated to roll out, but I think that's kind of really affirmed by the fact that traditionally it's supposed to come out with these manual updates, but we haven't really seen it. And that's why before you say, I'm screwed, we don't actually know if you're screwed or not, because we don't know on a practical level how this is actually going to be adjudicated. And there's some new terms that are out there that personally I haven't seen before. Like, what is the definition of extraordinary circumstances, right? Is it that you need to have a medical reason for why you cannot return to your home country? Is it that it's enough that you have a fear of your home country or there's a war occurring in your home country, right? It's kind of really unclear. And that's the reason why a lot of us are considering or thinking that this is going to be heavily litigated. Another interesting aspect is that there's no effective date that was established on the actual policy memo at this moment, right? Which is new. Usually a policy memo will be like effective as of, effective. There wasn't that language incorporated. So I will say that conservatively, we can sense that it's probably not going to be retroactive. It would be weird for it to be retroactive for those of you who have pending AOSs at this time. I think it just really frees it up to potential litigation. But I do think my anticipation is there's going to be more guidance. There's going to be a lot of pressure on the government in order to issue more guidance. And there's probably going to be litigation on this because there's so many elements of this that is not clear, right? I want you guys to hearken back to the 100K fee situation that occurred on September 19th of last year and how much evolved over the weekend in the same way that it's going to evolve over the weekend for us here leading into the next week. And I do potentially see litigation coming out of this. I see here a question. I filed an AOS with DOF current, got my EAD AP combo card, but my derivative spouse did not yet get EAD. So will this impact her getting EAD? Our final action date is not current yet. So I want to make it clear that the EAD card is a separate form from the adjustment of status, right? This is the 765. I also want to make it clear for every single one of you that the point of the stream is to be a little bit general, right? We still don't have a lot of substance to this memo just yet. I'm not here to establish an attorney-client relationship with each one of you, so I'll try to kind of answer to the best of my ability. But generally speaking, we are not thinking that this would apply retroactively to cases that are pending. And as a reminder that when it comes to EAD cards, that is a separate benefit request. Yes, it is tied to the AOS, but the memo focuses more on whether or not they're going to be approving the full adjustment of status, not necessarily your employment authorization document. Are those on F1 seeking to go to O1A from inside the US likely to be impacted? Also, won't they require congressional proceeding as this is part of the INA? These are good questions, right? To be very, very clear, the focus of the memo is on adjustment of statuses when people are going through their green card applications. The O1 is still a non-immigrant visa. It is not a green card process, right? So I don't think that it's really gonna have that impact that you think of, right? But be extremely mindful, Yash, of a lot of the changes that are happening if you're from a banned country or a country that's currently on hold. There's a lot of guidances that have come out on the later half of 2025, right? So I'm not sure where exactly that you are from, but we are not thinking that this is impacting non-immigrant cases. Also, won't this require congressional proceeding? Listen, like, I think I want to make it clear, I am not a federal litigation attorney, right? However, the one thing that I will say is that when I'm looking at this from the lens as an immigration attorney, I do feel that there's new concepts that are being thrown out there. I think I want to go back to what I said earlier, which is this concept of extraordinary circumstances, right? Extraordinary circumstances, I don't think really has a specific definition. Right? So what does that look like? What is the government going to be asking from us to prove that whoever is applying for an adjustment of status, right? Especially for those of you who are on single intent visas, right? Who have maybe a change of circumstances that would qualify you reasonably and you're not kind of violating truly your intent and there wasn't like a misrepresentation on your entry to acquire the process to get you to that AOS, right? We don't know. We don't know what the government is going to be asking from us. I will tell you that we have some feelings, right, in the direction of what extraordinary circumstances could be, but that's a new term. That's a new threshold. So I'm very curious about what the guidances are going to say. And maybe that also explains the delay, right, between what's going to be in the policy manual versus what was declared in the memorandum. What do you think about pending 485 and 765 applications through H-1B, right? So I think what you mean is that you're on H-1B status and you filed for an AOS while you're on H-1B status, and you also sought for employment authorization documents. So what I said earlier is true. I don't necessarily see immediately any discussion in the memo about benefit requests that are tied to the AOS. Fundamentally, the memo focuses on the adjudication of the green card application or that adjustment of status in this scenario, right? I find it very difficult for the government to apply this retroactively to cases that are currently pending. It does usually open up more room for litigation for those of you who have pending applications, because it's like they can't necessarily, quote unquote, suddenly change their mind or apply, quote unquote, new rules and new steps. So I would recommend kind of holding tight and taking a look at how the government updates this. I would be quite surprised if they decided to do retroactive impact. But again, hold steady, keep yourself updated on the news. I really do think that more guidance is going to roll up into the following week, if not more. Next question is, does that rule apply to those already filed with the 485, especially for those on F1 visa and filed I-130? Okay, so I think for those who already filed the 485, the hearkening or like the rule that I'm kind of thinking is going to play out is that it's usually not retroactive, right? This got released today. You filed your 485 maybe ages ago, a month ago, a week ago, right? So it's hard for you to kind of contemplate that in the initial filing if that wasn't expressed, right? It does usually mean that a lot of these new rules can be susceptible to the litigation if they do apply it retroactively to pending cases, right? So especially for those who are on F1 though, I want you to be mindful of one thing. I don't know if you have any documentation to show that you never had the intention to permanently immigrate to the United States upon your entry, right? What were your ties to your home country? What were the reasons that really required you to stay instead of going back to your home country to finish out that process? Again, noting kind of this disclaimers here, right? I do need to know more about your case in the long run if you want to have an effective analysis for each and every one of these items. But I will let you know that I think that to me, retroactiveness usually leads to more litigation, and I don't necessarily know if the government wants to deal with more litigation. Is the H-1B and O-1A dual intent? H-1B is dual intent. O-1 is an interesting one. It's pseudo dual intent. The Foreign Adjudicators Manual, or the AFM, which is what it's now called, they traditionally have noted the O-1 as dual intent. For those of us who have been working in immigration, we have been using extensions for O-1As even when people have pending 485 applications. But I think this is where the O-1 is in a little bit of a gray zone. It's not extremely clear 100% whether or not the O-1A is going to fall under this bucket of was it a single intent visa when it came in. But technically speaking, if you want to look at the letter of the law, for O-1s, when you file a 485, you can't change, basically you can't like leave before the AP or the advanced parole is issued to you. So it does function very differently from the true dual intent visas like the H-1B and the O-1, right? So I wanted to let you guys know I have a special guest that's going to be joining for this live stream. He's going to be on in like a second. His name is Mike Valverde. So Mike is joining in 1 second. So Mike Valverde is a former USCIS executive, and I think is probably the best person to really express to you kind of what's going on, what this on a practical level looks like, and also give you the same hints that I'm giving to you, which is that I think that procedurally this is very different from what we have encountered in the past. And yeah, let's go to Mike. Hi, Mike. Thank you so much for joining today's conversation.
Yeah, no, happy to join. I hope you can hear me and see me.
Yeah, 100%.
Awesome. Yeah.
But yeah, I think one of the things that I'm going to say right now is that what I gave to the general public so far is a very brief recap of what we are seeing. But I think, Mike, I think it's good to hear from your own words, like, what do you think is happening? Tell us a little more.
No, it's crazy. It is unprecedented, I think, to say the least. When you read the memo, and then you step back and you think about it, and there's some crazy footnotes in there. But what I think it all means is that the fact that someone here in the United States is applying for adjustment of status is now a negative factor in their consideration, right? For adjustment of status, there's eligibility, and then there's the discretionary approval. And USCIS always says that you could be eligible, but if there are negative factors, they will weigh against the ultimate approval of your case. In the past, those negative factors were maybe criminal issues that didn't rise to the level of inadmissibility or tax issues or something like that. Now they're saying the mere fact that you filed for adjustment based on this case law analysis, which I think is all suspect or challengeable, that in and of itself is a negative factor of discretion, unless there's an alternative adjustment statute. So your refugee, asylum granted folks, T's and U's, special immigrant juvenile. And I think I joined when you're talking about the dual intent folks. So absent those folks, everyone else has to start with that negative factor in the record.
100%. And I think one of the biggest examples that I gave to the wide general public and a lot of my counseling to some of the clients that we've spoken to today is like, imagine you came in on ESTA, right? Which is kind of like the lowest on the totem pole because it's a waiver of a status. You happen to meet the love of your life, you fall madly in love, right? You marry that US citizen and then you file that adjustment case based on that marriage, right? And I think those individuals need to be extremely careful about filing these cases moving forward because if anything, that's a hit against you because you entered with this intention to leave, right? But I digress, Mike. I think one thing that could be helpful for a lot of people, because this is a consistent question that we're hearing, is do you think this could impact retroactively? We have a lot of individuals who have pending cases at the moment. So what are your thoughts on that level?
Based on reading it and knowing how they work, I think there's a pretty good chance, that it is retroactive, that for cases decided, tomorrow, I guess they won't decide too many on a Saturday, and on Monday and Tuesday, they will be applying the new rules. So I do think that it is not just, I don't think it's safe to say that if you have your case filed, you're not going to be subject to this. I think it's going to be applied going forward. I think what we'll have to see is a factor. Is it like an overwhelmingly negative factor? Are they going to just say that's the end of the game? Or if you rock up to the application and you say, well, I've been in the community, I've actually founded this company and I've had, 7 jobs created and millions of dollars or whatever, and that's a positive factor. Will it be an actual objective of weighing of those things, or will it just kind of be an automatic thing? But no, a lot of words for me to say. I think it's going to be affecting every adjustment case from here on forward, whether it's filed today or if it was filed 9 months ago.
So I think that's interesting because I will say, right, a lot of the conversations that I've had so far, especially from the attorney's lens, is that wouldn't it feel like the government is opening themselves up to more scrutiny, potential litigation by applying it to retroactive cases? I think personally, I would be really surprised if they did. But even if they do, on a practical level, we've seen them try to do this. We've seen it with the 75 countries pause, everything like that. Right. But it does open them up a little bit to sensitivity.
100%. And in any normal time, that is why, I was always taught if the law changes or if you do an abrupt policy change, it's case going forward. And especially if it's a policy change, it's to protect you from that, equity that people who filed under the old rules have, right? They're able to say, I filed in good faith, I spent all this money, and now you change the rules midway, and then there's some ground and some harm there. I don't think these guys are, I'll try to keep it non-political. I don't think they have I think they have a much higher tolerance for litigation. So I also think this whole policy is ripe for litigation. So I think it's kind of they're going to shove it out there and see what survives.
So I think that's like another good topping point. And I think one very quickly for those of you on Instagram who might be commenting, if you guys want to see Mike's face and that interaction and comments, you can try to find us on YouTube as well. But feel free to still comment here. Our team is actually looking at a lot of the questions here and trying to forward it to us while we can see it. But I think this is a good tipping off point into a little bit about what litigation could look like, or what parts of this memo really throw you off, right? So Mike, I think I want to hear from you. What throws you off completely from this policy update?
Yeah, I don't know. I'll start with the fact that adjustment status is in the law, right? There's 245A. It's been there for decades, right? So there's reliance there. And I think some of the statutory changes to 245 have happened after the case law that they're pointing to, right? So, people who talk in these terms say Congress knew what they were doing. They knew the case law. They knew everything when they pass legislation, and therefore, you can't just write all of that off with a new policy, right? So in the sort of most litigious lens, this new policy sort of does away with the fact that 245A exists, that people can adjust status, right? And saying that by doing that, it's a negative factor for you to get your visa, right? That to me ignores everything that Congress has done. 245A, 245I, and 245K. There's all these provisions of law that allow people to adjust status, even sometimes after they've overstayed their permission, and Congress has allowed them to stay in the U.S., sometimes to pay a fee, sometimes to ask for a waiver, but to adjust status and get the green card here. Now the agency is saying, without legislation, without even a regulation, by this weird policy, we're not going to allow for that anymore. So, it's a balance of powers thing. It's a congressional, there's all kinds of, and, don't get me started. I guess I should have said at the start, but the case, the central case that they're using to base this on is about someone who broke the rules, right? The facts of that case is about, it's a removal case, and it's about someone who used misrepresentation. So they lied to the government. And so, essentially what they're saying is, for those people who followed the rules, the fact that you followed the rules is a negative factor in your case, and we're basing that on a case about someone who didn't follow the rules. So none of it makes sense, I think.
I think it makes my head spin, because I remember this case, right? And I felt at the time it was a little bit of a narrow finding, right? It was a very specific set of circumstances. And I also want to make it very clear to everyone here who might not be familiar with some of these provisions, 245A, all the like. A lot of these provisions are the ones that give you some level of coverage, right? Where sometimes things happen, right? Status gaps, certain types of overlaps, where the government's like, all right, we know, and congressionally they've agreed upon that we are going to give coverage for certain circumstances, right? A really big one that a lot of you who are on the stream, especially a lot of you who are running corporate immigration programs, might be familiar with, is that 245K rule, right? Essentially, there's a level of forgiveness of status violations or issues of less than 180 days cumulatively, right? And a lot of the times it's a little bit of a waiver. It's like, oh, my L1 expired 3 months ago, and now I'm eligible for the adjustment based on the EB1C. If I file it within that 3-month window, a lot of the times you're given this waiver of, okay, you can continue with the green card process because you had a good reason for that little bit of the overstep. Sometimes it's a misunderstanding of the rules that you thought you didn't have to extend just because you had that I-140 already approved. But I think what Mike is really explaining to all of you, and I think all of you need to carry with you, is that this is kind of mind-boggling, because Congress already kind of knew when they were passing these things and they were pushing these forward that there would be scenarios of forgiveness, and the sudden kind of threshold of negative factors, extraordinary circumstances. This is all new flourishments in my point of view. And actually that goes to Mike very quickly. Like, what do you think if I was sitting in the shoes of a USCIS officer, right? What kind of extraordinary circumstances would be out there that would say, oh, I can't go to my home country like Australia and I'm now in the US?
Yeah, it's difficult to know, because one of the things I think, just from watching from my perspective, that I'm pretty sure of, is that not a lot of people in the agency knew about this, and therefore the cases that are going to be decided on Tuesday, I guess it's a holiday weekend, so maybe no one will do it tomorrow, Sunday or Monday, will be decided where the officers don't know about this policy memo, or the only thing they have is this policy memo, but no instructions on any of those questions. Like, is this a really super negative presumption, or what, to your question, what exactly can they use to overcome it, right? And I think different minds in the agency will have different opinions on that. I mean, the normal way that back when I was there, we would talk about whenever there was a use of discretion, was you look at relationships to U.S. citizens, you look at time in the country, you look at volunteerism and activity in the community, anything from, do you support the farmer's market, or do you go to church, synagogue, temple, or whatever? Do you volunteer? All of that now becomes really important when you're thinking about your adjustment of status, because you're going to have to overcome this presumption. And I guess we're all going to learn at what level, how seriously is the negative factor, and how are they going to train, 5,000 or 6,000 officers to apply it in a consistent manner. I do wonder though how they, so if they deny a case based on this new policy, they have to write it up, right? As you know, denials in the U.S., unlike at the consular stage, get a pretty thorough write-up. So someone's going to have to write through that analysis that I just talked about and say, okay, Nicole, you're eligible. You meet the criteria, but in our discretion, we're not going to approve your case because you are an adjustment applicant. We have weighed that against the positive factors that you are, a smart person that manifests law and you've done X, Y, and Z. And so they're going to have to write that up. And I kind of think that first time they write it up, they're going to have to be super eloquent because that's going to be where the litigation starts. And they're going to have to defend it all.
Yeah, and I think that leads to a reasonable question, and I see it coming very quickly, which is that there's this fear of what we call descheduling or rescheduling as like a response to this memo. Do you think that's pretty realistic in the scenario as the agency is figuring out, right? Is it that my appointment that I had for my interview for my 485, could it be descheduled?
It could be. I think more is the case that you just might not walk out of the appointment with a decision.
Right. That's true.
Or maybe they will, who knows how comfortable they are with it. But I was just asking myself, if I were still at the job, so not to get into my background, but one of the last jobs I had would have been telling people how to operationalize this. And I was thinking about that today, and I was like, I have no idea how I would tell people. So someone's going to have to write up the agency take on this and say, we're going to be really hard on this, or we're going to be reasonable on this, or this is how we're going to do it. And then we have to share that out to all the officers. And that is, that's what we'll learn over the next few weeks, is how they're going to operationalize this.
So I think for the wider crowd here, that's what I also want you to take away, especially coming from someone like Mike over here, who has this experience in operationalizing with USCIS, that even in his position where he's supposed to be training, kind of giving the direction for the agency and the field operations in particular, the field officers, right? I don't even know where to begin. Right. So that's the same gut reaction that we have as attorneys, is that when we're looking at this memo, we're like, where do we even begin? Right. What do we prep for? How do we prep for this? Because a lot of it is just kind of like this mishmash. I felt like it was like a hodgepodge. They're putting together like this paper mache, like version of like what is a memo, but isn't really a memo, right? Because I remember that the first thing that I said, especially to my colleagues, is, man, they're really redressing case law that already existed. We knew that they had a discretionary authority. They're trying to really angle this as something that's brand new, when I think it's really more so new in enforcement level and establishing of standards, right? But I think where it kind of goes back to some of the common questions here that we're seeing, right? This concept of extraordinary circumstances, proving the merit of having the green card, right? Of getting this green card. Many people here that are in the chat are individuals who garnered EB2s through the NIW process, a national interest waiver. And there's this little bit of a misnomer within the community that's like, if I've proven that I'm doing something of national interest, then by virtue of that, I've proven my merit. Thoughts on that, Mike?
Well, I can see why they think that, right? Because as part of the national interest waiver, you show why you don't have to go through PERM, and it has all of this sort of immigration adjustment like language. You don't have to go through all this. You can file for adjustment without that. And taking it all out of the NIW category, there's 601A waiver or 601 waivers where you have to show extraordinary harm or whatever to U.S. citizens, and that word is all throughout the statute in different ways. But I guess I'll go back to just what I said before. And kind of what you said, the word extraordinary isn't in any of the adjustment law or regulations. So I don't want to say they're making it up, because I'll give them credit. They have their memo and they cite it to case law, and they're reading it in a way that, I guess they have the prerogative to read it. But that's new. They're making that new assertion. I don't want to say they're making it up, because I wouldn't
say that they're making it up. I think it's really more like establishing an interpretation that is a
Yeah.
bit different than the way that a lot of others have been reading it, right? So I think where we kind of want to dive in a little bit more into some of the questions that we're seeing here is there's a lot of questions related to marriage to a U.S. citizen, or even let's call it immediate relative petitions, right?
Yeah.
Where maybe you have a child who is a U.S. citizen that has turned 21 and they're immediately sponsoring you for this green card. There's no visa bulletin contemplation here, right? Mike, I guess my question to you is, what were the protections that existed for those individuals before, and what should people be mindful now about those protections moving forward?
Yeah, I mean, I've been trying to look at the memo from that lens and from a whole bunch, right? And so if you're talking about the 245C protections, right, if you're an immediate relative of United States citizens, you get some grace. If you were admitted as a non-immigrant properly and you overstayed or you worked without permission, that category gives you grace and you can still adjust status. Everyone else gets in trouble for that. That's a status maintenance issue. Here, again, they know enough to say they can't just override the law. So they're going to have to say that 245C still exists and you're technically eligible to adjust status based on that. But again, the agency has a two-step consideration where they say, not only do you have to be eligible, but we have to decide in our discretion, are there enough positive factors that outweigh any negative factors? And all of a sudden, this is what I think you're asking, that overstay or that working without permission becomes a negative factor.
Ooh,
and
right.
works against you.
Because we always thought about this whole entire kind of overlooking, let's say, of the situations that people find themselves in, especially through marriage or immediate relative, as family reunification, right? We don't want to keep families apart if it is truly the love of your life, and we want to be committed to keeping American families together. That was really the basis or the spirit, right, behind a lot of these coverages based on marriage or, children over the age of 21 sponsoring their parents. I think it's quite fascinating how a lot of this has played out so far. I think another point that a lot of people are asking about is, so what does this mean, right, if I get denied here in the United States for an AOS and I'm being told to consular process, right? I understand, Mike, that your involvement has historically been on the USCIS front, right? But I think my question is, how are they going to transfer that case to the consular processing unit, like to the NVC? I think just to give you guys some context in the general public, right? Whenever we file for an I-140, there's two boxes that we have to check, right? We're either going to check the fact that this is going to be for an adjustment of status, so this basically gets held under USCIS, or we check off a box that says consular processing, where that I-140 approval gets sent to the National Visa Center, and they open up a case with the Department of State to start collecting the documents and the information that they need in order to process the case at a U.S. consulate, right? But if you don't select consular processing, right, I will tell all of you that we needed to file a separate form to transfer that case from USCIS to the U.S. consulate. So, Mike, inner workings here, right? The transferring of cases. How is that going to do? How do you think that will impact everyone?
I don't know. I mean, the government could do it. It is all in databases, and more they're talking to each other. And part of the actions that you take when you deny a person's adjustment of status case could be, in whatever circumstances you figure, as part of you hit deny, that deny sends it over and starts that process at the National Visa Center that you just spoke about, right? It could be, deny for adjustment of status, otherwise eligible. That could be a category, and that could automatically be sent over to state. So they could do that. They have the prerogative to build that link to perfect that link. I don't know if they will, but that's easily done through technology. If not, then it's the government. So there's a form for it. You file the 824 and you move it across. I suspect it won't be automatically done. I don't think they're looking to do favors for folks right now. So I think you'll have to utilize something like the 824 and make a specific request to do consular processing.
Got it. And I think there's a little bit of confusion in the room right now, right? Like, let's say this memo does hold in some form or way, right? And now I have to prove, to me, the way that I break it down is like these two different elements, right? Number one, especially if I'm in a single intent visa, that there were quote unquote extraordinary circumstances that requires you to do the adjustment, right? And then number two, which I think is a little bit more impactful even to individuals on dual intent visas, this concept of merit, right, behind the green card. It's not automatic just because you prove the I-140 and your eligibility for the I-140. There's like a level step above. So let's break it down. Extraordinary circumstances. I want to make it clear to the audience here that there's no confirmation on the definition of extraordinary circumstances. So the first example that I'm going to give is sometimes there's medical reasons, right? Like physically, I am incapable of even moving to outside of the United States because of a medical grounded reason, right? So Mike, I guess to your point or to your take, right? This concept of extraordinary circumstances, do you think it's going to be akin to that kind of analysis, or do you think it's going to really be restrictive? Starting to feel that it could be more restrictive.
Yeah, I mean, this administration has not given signals that it won't be. That's a double negative answer. I think you're right. I mean, I think if I were to bet, my dollar on it, I'd say they're going to take a hard line on it. What's the point of the policy if they're not? Otherwise, I think, we'll see over the next few weeks how seriously they're taking it, right? There's a spectrum there of how seriously they can take it. But I think recent history has shown it's pretty likely that it'll be extraordinary means extraordinary, not ordinary, not common, and they'll define it like that.
Got it. And then it leads me to the second point, which I think is probably going to impact most people. A lot of the times you are here on a valid dual intent visa. A lot of workers in the workforce right now, especially in STEM, are individuals on H-1Bs, on L-1s, right? So what about this question of merit, right? Like behind like this green card, instead of it being like, I have this right or entitlement to the adjustment process, tell me why I deserve this green card. What does that look like to you?
Yeah, that policy has been out for a while, where the government has said they intend to start being more serious about that. I call it the second step, right? There's eligibility, then there's merit. But you might know, Nicole, and you can disagree with me, but my sense has been that there have been a handful of cases I've heard about where in interviews people have asked a question. Okay, you're eligible, so why should we approve you? A lot of interviews they haven't, from the practitioners I've spoken with, but that's simpler, and that's where I was talking about before. That's where you have to say, not only was I not arrested, but I started this business, or I've been working for this employer and paying my taxes, or I'm a volunteer. That's much less high bar than I think they can make the extraordinary. That is just on the whole of things, I'm 51% likely to be a positive community member, right? It's almost like that. Whereas extraordinary suggests way above normal standards.
So I think like the way that us practitioners have seen it so far, and at least personally how I've seen it, is that I've seen it come about in twofold, right? I want to remind you that I wouldn't say that every single 485 has gotten to the interview, right? I think a lot of people who have filed 485s based on an I-140, which is an employment-based petition, usually don't really have an interview, right? And that doesn't mean if you get called in for an interview that you need to be worried and, oh my God, the world is ending. Like sometimes it really could be random chance, right? Funny note on that, sometimes I've seen officers actually tell the foreign national, I've never done an I-140 interview based, like an I-140 based interview for 45. But it tends to lead to a longer wait time because they're trying to figure out what they're supposed to do. But kind of taking that aside, right? It is true. A lot of the times where this question comes up is not even really in the application stage, right? For the 485, it's actually maybe one or two questions that we've seen at the interview at most, right? And that goes back to preparation. So for a lot of you who have been very compliant, who have, done the right things, you've invested your time in the United States, you have the positive equities, you've been a beneficial member to the American public and to the American economy, right? It's making sure that counsel advises you and really puts you through the motions of what do I say when that question comes up, right? What makes me a good person, right? I try to make it as colloquial as possible and accessible, right? It's like kind of selling to the officer, or think of it as like a job interview of what makes me so great, right? This is not the time for you to hesitate. Please peacock your feathers. I've built the latest and greatest in artificial intelligence. I've built all these kind of cool things that I think would be helpful for the American public. I've built open source frameworks that have really elevated the general public's ability to do X, Y, and Z. Or for many of you who work even in finance, right? I've built tools to protect the consumer from fraud. Like, think about every single good thing that you've done, even going down to I volunteer at my local soup kitchen. I'm just genuinely a good person that has brought merit that is behind not only this application, but to the United States. And I think that it does go back to interview preparation. And I think where we're in the land of speculation when it comes to the memo is, again, the practical kind of follow through of this memorandum, right? What kinds of questions will the government be asking now? What kinds of arguments are they anticipating in these initial applications that are going in for the 485? Right. So I really think that that's something that a lot of you need to be mindful of, especially if you haven't filed your adjustments yet. Right. If you are planning to file your adjustment of status this month or in the next month, whether it's based on the visa bulletin or the immediate relative petition, the biggest note that I have for you is, number one, talk to your immigration attorney. This is all a case-by-case basis scenario, right? But be prepared to either provide more documentation, more information, so that your attorney can effectively make that argument, assuming that all of this is going to carry forward, right? That, hey, you have this merit. And additionally to that, if you are someone who's on a single intent visa, what is this change of circumstances or the extraordinary situation that you find yourself in that requires you to do that adjustment, right? So don't panic, call the professional that you need to be relying on to interpret this for your case, because I know many of you are asking me very case-specific questions, but I don't know the full circumstances of your filing. Same thing goes for Mike, who is sitting on this call, trying to give us a very general overview of what he thinks is going on right now. I think one thing to kind of add, Mike, that would be very helpful for the crowd is something that I've talked a lot about with a lot of other advisors and a lot of people who are in a similar position to you, right? Is this surprising notion of how this came out as a policy memo, but it doesn't seem like there's manual guidance. There's actually an afternote in a way in that memo that's like, hey, we're gonna send out guidances based on case type. We'll get there soon, right? So what do you think on an operational basis here, right? Like, this rollout just seems different than some of
unfortunately, I don't think it's very different. There is of late, right? There's a very high level of concern about leaks in the immigration policy space. Certainly at USCIS, to the extent that I haven't heard about it lately, but at the time I was leaving the agency, there are a lot of lie detector tests and things like that. So the practice has been where they develop the policy, they keep it really tight, and then starting maybe today or next week, there'll be fast and furious development of how you instruct officers on how to do the policy. I think that, the reason for its timing today, I can only guess that they were working for a while on just the right words, right? Because, I'm coming at it from my perspective and whatever, and I'm seeing legal pitfalls, and maybe I'm wrong, but I think they had to work really hard to get the right words to make it, to sell it, right? To get it close enough to being legal, so that they could put it out and then build the things that they're going to build next week, the operational ways that people are going to adjudicate cases. And that's why, I think you're right, Nicole, to sort of tell everyone a lot of the really specific answers. Don't let anyone tell you they know, because nobody knows how this is going to go until you start seeing how cases are adjudicated. You can make your best bet and read up and see what the memo says and talk to your attorneys, but it's going to be how they roll it out and operationalize it. And they haven't developed that yet.
And I think it's a reminder for every single person here. I want to harken back to like the biggest policy shift that we saw under this administration so far, in my point of view, was the 100K fee, right? Like, so much evolved from September 19th all the way to what I think is like October 19th, right? Like, we started with a live stream from the government that's like annual fee, right? Every year, $100,000, right? Any H-1B renewal, et cetera, like that's all going to be shoved under 100K fee. right? And then you get like over the weekend, we got two guidances, actually three, right? We got one from USCIS, we got one from CBP, we also got one from the Department of State, all saying slightly different things, really enough, from each other about, oh, here are all the exemptions, right? And then in the weeks thereafter, we got USCIS FAQs clarifying that, hey, if it's a transfer and they're here in the United States and all these kind of more exemptions to the rule, they don't have to pay the 100K fee. And then later on, we got more clarifications about the lottery and how that's going to work with the 100K fee. So I think for many of you, I want you to kind of harken back to that era. There was a lot of panic on the first day that this dropped, right? I'm going to bust out of my plane, get back to the United States, get on a boat, row myself to the US, right? And that was very, very real fear. But I think what we're going to see from this day moving forward is a lot of updated guidance. I can only perceive that that's not only public pressure, right, for more information, whether it's from journalists, the wider community, but also from companies as well who may have direct connections with the government being like, can you please clarify this, right? We really need a better understanding of what you are looking for because it impacts the populace that I'm responsible for, but also because clarity is definitely needed because we just don't know if we want to file. And some people are really trying to be compliant. Like if you want me to leave and you want me to do consular processing, I will do that. But someone needs to tell me when, where, how, and why, right? So I do implore very much to all of you, please do not immediately go, I am so screwed immediately. A lot of this is probably going to be subject to change as it rolls out. We do think, at least in my really strong personal opinion, I see a lot of things here that are ripe for litigation. Does that confirm that people are going to litigate? The answer is no. At the end of the day, I am not a litigation attorney. People are not paying me to try to litigate. The reality is that having sat here working through a lot of the motions, whether it's under the previous version of this administration until now, we do see a lot of areas where litigation can come up, especially in a scenario where a lot of new language is being introduced. But all of this is to be said, right? Okay, so now we're going to go back to some of the questions, and Mike, feel free to kind of chime in as I like bring up some of these questions if you would like to consider this, right? So we're going to start with some of the more, I guess, straightforward questions that I think are widely applicable, right? So I think it goes to, for an Australian on E3 visa with a pending or approved I-140, does this memo block them from adjusting status and force them into consular processing? So I'm going to break this down actually weirdly enough into each section, right? Reminder, E3 visas are not dual intent. I want to make that very clear. There is a misunderstanding a lot of the times because there are parts of other e-visas, like the E2, where they have some pseudo protections out there in the FAM or the Foreign Adjudicators Manual. They're like, oh, even if they have an approved I-140, so long as they stated they have this intent to depart, no big deal, quote unquote, right? But the E3 is very different. It is definitely not a dual intent visa, so be mindful of that first, right? The second thing is pending or approved I-140. What's not being judged in this application is your I-140. What's being judged in this memo is your adjustment of status, right? And I want to make that very clear. And I think, Mike, you can also make it very clear to the public. This memo focuses on AOS, right? Not necessarily the underlying basis of the AOS.
Yeah. I mean, and the other thing I would add to that, it doesn't, you know, I guess the word block is carrying a lot of weight in this sentence too, right? It doesn't say that you can't apply. It, you know, the memo would say that whatever the policy is, however we learn how they're going to operationalize it is how they're going to decide it, right? So the memo could require you to give those extraordinary factors that Nicole was talking about. That, I mean, I think instead of blocking, I would say, does the memo apply to me? And if it does, that's what it means. It would then require that you show why you should be allowed to adjust status here in the United States because of some extraordinary reason.
Right, right. So I think just to kind of conclude this particular question, and also we're going to say a brief goodbye to Mike, right? I know, thank you so much again for a lot of your insights. I think it's very helpful for the wider community here that is joining us for this particular call. But to close up this particular question, does this memo block them from adjusting status and force them into consular processing? There's no force here, right? There's nothing actually in the memo that prevents you from actually filing the 485. But it's that the government is explaining to every single person who is thinking of filing an adjustment of status, think to yourself, Do I have an extraordinary circumstance, especially when I'm a single intent visa? Is there a reason why I'm doing an adjustment of status, right? And then going back to this merit conversation of, do I merit or warrant the underlying basis of this green card, right? Do I quote unquote deserve it, right? So you can technically still file a 485, but be prepared for this new level of scrutiny. But again, want to make it clear, we actually don't know how this is going to be applied on a practical level, right? So before you make a decision over this weekend, I'm going to just do consular processing. Please do not do that. Take a step back, take a breather, wait until more information and more substance comes out of this memo before actioning. But thank you so much, Mike, for joining us on today's conversation. I really appreciate your insights, right? Yeah, I think, thank you again. And I think the astounding set of circumstances right now. So bye-bye. All right, guys, continuing with the questions, right? I think this is like the part that a lot of you are here for, right? Let's go into what about the O visa? So I did answer this a little bit earlier but many of you who are joining in today's conversation, what about the O1? The O1 is in this weird gray area where it's not really a true dual intent visa, right? The H-1B and the L-1 are true dual intent. And the reason why I'm going to express this in a very straightforward way is when you file for a 485 or an adjustment of status on the H-1B or an L-1, you could technically leave the country and then come back to the United States without abandoning the adjustment of status application, even if you don't have the advanced parole or travel document that's attached, right? And that's because they have a dual intent provision. You're allowed to have the intention to permanently immigrate. The O1 doesn't have that protection. The O1 does not, right? So even though on a practical level and in practice, a lot of people do file for renewals and extensions during the pendency of a lot of these adjustment applications, we actually don't really know how the government's going to be treating the O visa because it's not really a true dual intent visa. As a reminder to everyone who has just joined the call, what we are talking about today is this update related to adjustment of statuses, extraordinary circumstances, the impact about this level of scrutiny that the government is going to be imposing, it seems, when it comes to these applications. And we're here to really talk you guys through it, right? Next one that I see here is what are the odds of an AOS application not being sent to consular if on F1 to green card? Would reasons like US citizen child or 75 country immigrant visa pause be a good reason for AOS? Let's talk about the latter first, right? I think there is a question about US citizen children. It depends on how the officer wants to interpret it. But if there's a level of hardship that's going to be encumbered on the US citizen, personally as an attorney, if I was trying to argue an extraordinary set of circumstances, maybe the argument that could be relayed there is my US citizen child will not be able to survive if I pulled them out of school or whatever resources that they need here in the United States. What if there's a medical issue related to their child and they cannot get access to that healthcare abroad, right? For the 75 country immigrant visa pause, I don't think that's a really good set of answers for extenuating circumstances. It's basically telling the government like, well, it's because I just can't do it in my home country because you're not allowing me to. So I would kind of hesitate with that point. But again, I think for this particular individual who asked that question, it does really come down to what are your specific case circumstances. If you are in the middle of an AOS or you are planning to apply for an AOS, I really think that you need to be talking to counsel, especially if you think that the 75 country ban is going to be something that impacts you at this moment. What are the odds of an AOS application not being sent to consular? I can't speak on the odds, right? The one thing that I will say is that there is a heavy emphasis in this memo, right, about single intent visas and the fact that when people first enter on this single intent visa, at some point or another, you told an officer or you told someone of authority that you intended to depart, right? So I would keep that very much in mind. I think the next question that I would say is that here is like, I have no gap, always lawful, no criminal record currently on H-1B, have an approved EB-1, I-140, already filed AOS with my spouse as my derivative. Are we at risk, right? I don't know what you mean by F1. If your spouse is on F1, then I think that's a different analysis. I have to remind every single person here, right? When you file an adjustment of status case, right, and you have a spouse, it's not like the government sits there and they go, okay, if the primary is approved, the spouse is also approved for the adjustment. Each adjustment case, right, each AOS is adjudicated on its own merits, right? So I, as the primary applicant, need to be a good person. And my spouse also has to be a good person. So when you have, let's say, a spouse who filed based on an F1 single intent visa, whereas the primary applicant filed under an H-1B, which is a dual intent visa, the analysis might be different. The analysis really could be different. And that's because on an H-1B, you had that dual intent provision and the F1 did not, right? So I think that's what you need to be thinking about for this individual when you're talking to counsel is, well, my wife has a different analysis than myself because my wife applied under a single intent visa. Timing, consideration, extenuating circumstances, these are all the things that you need to be thinking about for those scenarios, right? Going to, would an NIW justify it is for interest part? So Mike Valverde, who was here earlier, had a really, really good point about this. It is easy to understand why people think if I applied through the National Interest Waiver Framework, doesn't that already fill in it is for the interest or the benefit or there's merit behind the application? There are elements of an EB2 NIW case that you can raise as part of that argument, but it's not like an automatic provision. There is still an argument that needs to be made. And many of you who have gotten NIWs, maybe you acquired the NIW years ago, right? A lot can change from the time that you applied for that NIW and you got it approved to the moment that you are filing for that adjustment. And I will also make it very clear that it's not just the NIW. What are you filing from? What if you acquired this NIW while you were on an F1 and you were still on an F1 filing that adjustment? That's what you need to be thinking of because there's really two parts of this framework, right? There's the analysis that goes into what was your intention, right? You were here on a single intent visa and now you are telling me that you need to do an adjustment of status, which is discretionary, right? Why aren't you consular processing? And then the second part, which is going back to the merit behind the qualifications for the green card, which is why do I deserve this green card? But again, I think for you in particular, please talk to counsel when it comes to your NIW. The basis, it really does depend on where you're at in this process, right? This is a good one that I saw coming in as we were talking about cases, right? Historically, marriage cases had a lot of coverage through 245C, where it's like for the purposes of family reunification, the government would overlook a lot of maybe status violations so long as somebody made a lawful entry of some format, you didn't illegally enter to the United States and you were not, they call it entered without inspection. So if you did not, or if you did enter without inspection, that's where a lot of the coverage kind of fails here. Right? I see that some people are saying like, maybe we need to apply through a different way, which is like the immediate relative pathway that doesn't have to do with marriages. It's not the main focus. It's all adjustment, guys, regardless of the basis, still has this focus, right? I do think that there is a lot of, let's call it media and a lot of headlines talking about marriage cases, because that's the one that usually gets a lot of interviews that are in place. But that doesn't mean that for cases based on having a U.S. citizen child, for example, that you're suddenly absolved from this memo. It's definitely going to really be in play so long as they are able to operationalize this. And we're going to look at the guidances as they come out, because this is, to me, very much a developing story, right? Going into this scenario here, right? I think some people have saw this question come up, and I want to make it very clear. It says here that they had their 485 pending for the past 1 year, and today I got an update saying my interview was canceled, even though there was no interview scheduled. What does that mean, right? It's hard for me to say. You're saying that there was no interview and it got canceled. Did you miss an update perhaps in between, right? This is where you want to go back to counsel, and I do want to flag to every one of you here. I did ask Mike Valverde, do you think there's potential instances of people getting what we call descheduled or rescheduled, right? Descheduling means that you're taken off of the interview kind of appointment, and they're not confirming whether or not you're going to be rescheduled anytime soon, or you were immediately rescheduled where you're given a new appointment, right? There's that potential reality that as the agency is working out the trainings required in order to get this discretionary kind of threshold established, because just to remind every one of you, when you do a USCIS process, there needs to be a denial notice if they opt to deny the case. And that denial notice needs to still explain, elucidate, detail the grounds of why you are getting denied. And that does require training under this new framework number, because they need to kind of explain, like, why is it that the extraordinary circumstances did not arise to that level, and everything related to that qualification or merit-based analysis as well. So it is possible, right? Mike Valverde also said another possibility is that if you go to that interview, they might ask for a continuance, or essentially they'll say, hey, we can't adjudicate this right now, we'll reach out back to you later on. Like, that is definitely a possibility as well, right? Going into the next kind of question, right? I see here, what if you're marrying a US citizen? Are you still have to leave the country? It's hard for me to answer that because it depends on the basis, right? I think the people who are most impacted by this memo are individuals who came into the country under a single intent visa, like the B1, B2, or like a waiver, like an ESTA, right? Where you don't actually have a status. If you decide to marry a US citizen and adjust based on that basis, then it does call into question a negative factor, which is that you told the government and you affirmed to the government that you were coming here under the impression that you were going to leave the country. You are a temporary visitor here for business or for tourism before deciding to do this adjustment process. So please explain to us, right, why this happened. What is the extraordinary circumstance that's behind it, right? They do take it as a negative factor if you are kind of committing those kinds of actions, it seems, at least based on this memo. But again, before people hit the panic button, there's a lot of guidances that are rolling out. Probably in the next few weeks, we're going to learn a lot more, because behind this memo, which has a lot of words and a lot of things, right, there's not really a lot of quote unquote like substance beyond like the case law. We have not been given the practical guidance of how they're going to operationalize this, what kinds of questions the officers are going to be asking at the interview stage. Like, a lot of that is going to come out in the next following weeks. And the government also hinted at that at the memo, where they're saying, hey, we're going to establish it based on like case types and certain scenarios. So please be on the lookout for that. And we're going to be updating it as we kind of find out. I do believe that the agency is probably working out those kinks here for those types of applications. I see here, I do have an NIW petition pending, and I am on an E2 visa. I do have travel plans on the E2 in June. Should I be worried? Well, first of all, right, I think it's kind of interesting that you opted to file for an NIW petition when you're on an E2. Remember that an E2 is not a dual intent visa. It has some protections when it comes to the renewal of the E2, right? But at the end of the day, right, when you enter back to the United States on an E2 after traveling, an officer is allowed to ask, like, well, maybe they see in the system, right? There's no proof that there's like this database that's out there that all the officers are looking at, including CBP, right? But I can foresee them saying that we see that you have a pending green card application. And I also don't know what you selected in that application. Did you select that you were going to consular process it, or did you select that you were going to do an adjustment? Because if you filed it with an adjustment, then that does call into question whether or not you have the intent to depart as you're required to on the E2, right? So I think for you in particular, you should be talking to counsel who either advised you to do this NIW petition or is involved with your E2 process, because I really think that you need to talk to a specialist. You need to talk to a lawyer in particular to advise you accordingly. Because in my case of first impression, at the end of the day, I don't know the whole circumstances of your application filing. It's not something that I'm excited about, to say the least, right? Going into there's a lot of questions coming in, and I'm trying, right? Can anyone sue this memo, right? So lawsuits are interesting. Technically, anyone could theoretically sue the government, but always remember that you need to have meritorious grounds for it. You need to have something known as standing, right? My perspective when it comes to lawsuits is that it's usually the most impacted of individuals. A lot of the times, if you're trying to make a lot of, let's call it, change occur, especially when it comes to government-related actions, people are building up towards a class action lawsuit. There's a whole class of individuals that are being impacted by this, and it can take a little bit of time to collect those. So sometimes what we start with is maybe smaller lawsuits from one individual or a family, right? And then what it gets expanded upon very quickly in the following weeks are class-related litigation. But I want to caveat all of this that I am not a litigation attorney. I have a deep respect for the litigation field, which is very different from immigration, generally speaking. A lot of my work has to do with handling corporate immigration programs, dealing with extraordinary ability visas and the like. I have worked on my handful of AOSs and the like, and the reality is that when it comes to the litigation front, it's a very different ballgame and a very different battle to be had. But we are anticipating some level of litigation on this because It just seems to be a very wide-reaching memo here, right? And that's what Valverde really said, is like, it just seems to be kind of ripe for a lot of litigation, and that we are, as an industry, pretty much expecting it to some point of view, right? I think that there's a lot of other questions here where our AOS was filed 2 or 3 weeks ago, but we haven't received the confirmation and the tracking number. I will say that in my perspective in this scenario, very quickly, is that it does take time for these receipt notices to come in. For adjustment of statuses, I've seen it take 4 to 8 weeks. They go to a lockbox, and it's not like premium processing where people usually get an immediate notification. It does take time, right? And the only reason why I know this very, very well is because we've had some instances where people had credit cards that were valid for the month. And then when they filed it, they got a rejection because the following month, the credit card was not valid anymore, right? So the reality is that at the end of the day, there's no confirmation number that's like associated with it just yet. Sometimes it can come a little bit later, right? Going into the next part here, what about L1A with approved I-140 and pending AOS? I think this goes back to the question of pendency of applications and how we think that the government is going to be treating it. And I think it's interesting because it depends on the practitioner and the individual that you were talking to. So I'm going to first declare what was stated earlier in our presentation so far and in this webinar so far, which is that Mike Valverde, who is a former USCIS executive, basically stated that he thinks that it could apply for pending applications that haven't been adjudicated yet and new applications moving forward. However, taking a step back, what was acknowledged in my conversation with Mike is that if they decide to apply it retroactively to pending cases, it does leave them a little bit more ripe for even more litigation, right? It's kind of hard to apply things retroactively when people didn't know that this was another layer of adjudication, that they needed to prepare evidence and provide evidence of this, right? So the reality is that I think that it just kind of depends. I think that if the government is trying to be a little bit more conservative and not be as ripe of potential litigation, they might just avoid applying it moving forward. I think it's interesting that the policy memorandum does not have an effective date so far. But yeah, I think there's two perspectives here. As lawyers, we're kind of like, do they want to litigate? Do they not want to litigate? For Mike, I think he's saying that it seems that under this administration, they might have this appetite for litigation, right? I think there's some other questions here that I want to see, right? I think the one that I do want to address is here is, I am from the 39 countries on hold. Should I join a lawsuit given it's risky as I have only a pending 45 filed before the new memo? I see a few individuals, or I see a few questions here about joining a lawsuit or not, right? I think it's hard in my position to tell someone to join a lawsuit, right? There's questions about out there, and I don't think that these are real or not. Like, what if the government doesn't like the fact that I was involved in a lawsuit? What if the lawsuit ends up failing? What if there's costs that were established today? There's a lot of things, right? I think what I have to say about all of this is that it does really depend on your case, right? I really think that you should be going to your immigration counsel or your litigation counsel that is involved here and having this question go up to them, which is like, hey, is this something that's going to impact me? Would it be potentially fruitful for me to even get litigation involved, right? So I think that's like a real honest question to kind of push out there, right? Going to more questions, right? Would be lovely if this leads to more overflows into backlog countries. I think it becomes a question, right? Because one of the things that did occur, and it's hard to prove because it's not like we have the calculations that the government made, the 75 countries pause did lead to a little bit of a trickle-down effect where a lot of other countries became available for filing and for this final action dates kind of moving forward ahead. Is it possible that this could introduce another layer where, hey, there's more availability? Possibly. But I do think, again, it goes back to it being pretty ripe for litigation, maybe even more so than a lot of the pauses that were occurring so far, right? Let's see. I entered the US with B2, then transferred to F1, and alongside my AOS EB3 under process RD. So I will say this again. I think it's like the question of intention, right? When did you enter on the B2? When did you transfer to the F1? And you said alongside the AOS for EB3, that's a lot of concurrent applications that are going out. You need to talk to counsel. You need to talk about the timing. And you need to be prepared for those questions that come up, which is that, what was your intention when you entered on the B1, B2? Was it that you were going to do a mini discovery trip to see if you like universities here and that you had a round trip ticket, right? Is it that when you went to school, you happened to get a fantastic job offer that allowed you to get this EB3? Like, I think these are all relevant questions that you need to really be thinking about before you even consider going forward with the process, or even like the actual interview component that could come up, right? So it's not that I think whether or not you're going to be affected, it's that you really should be talking to your counsel, whoever helped you file a lot of these applications, right? I think just going, because there's just a lot of questions that are coming in, right? I see here, I think it goes back to the descheduled or rescheduled. You're saying that even though I did not have an interview scheduled in the first place, right? I think the first thing that I'm going to say right now is that kind of sometimes there can be errors in terms of the submission of the statuses. It's very possible that it was very quick. They did issue an interview notice, but suddenly got canceled, right? One thing that you can consider doing is maybe an e-request or chatting with Emma to see kind of any information about the statuses so far or leading up to it. But at the end of the day, I think it's kind of like a wait and see. Whoever was counsel that helped you with the filing could probably give you some information or insight into what happened here, because unless I know a lot more about your case and you did a consultation, what country were you born in? What is your citizenship? What is the basis, right? I think there's a lot of open kind of discussion there to be had. I recently did my interview in March end, no decision, employment based. What am I supposed to do? It's kind of like a wait and see scenario, right? I also think that this is where you can ping some of your attorneys that were involved in the case, or if you're working for a company, like reach out to the appropriate contact to see if you can get some guidance here, right? At the end of the day, it really depends. What was the status that you were in when you filed for this? Were you here on a single intent visa? Were you here on a dual intent visa? What were like the grounds that were associated with it? So please kind of think about that as well when you're kind of navigating such a situation like this, right? I think kind of going into some of the newer comments, I see here, what do you think of an L1 already expired with approved EB3 I-140 pending AOS authorized stay? Authorized stay and tolling provisions. I feel like when I'm looking at this memo, it doesn't really talk about what happens when you file timely, right? Like how are they going to treat those situations? But the good news is that you filed it. It seems probably timely while you had the L1 valid. If not, I think where questions come up is if you were relying on 245K, right? Which is that the L1 had already expired, but then later on you filed for that adjustment within that 6-month window of time, right? That's where you need to really be talking to counsel. But even then, right, I don't think the government has really said one way or another how they're going to be treating the scenarios where they're here on authorized stay. But authorized stay is authorized stay. I think timely filing gives you some level of protections because it's not really discussed in this memo just yet. Do wait on some of the guidances over the weekend. Talk to whoever helped you with the EB3. Usually that would be corporate counsel that was involved with the process, right? But I think it does come back to the more pressing scenario is if you filed post the L1 expiration. Are all 485s going to be denied? No, the answer is no. Not all 485s are going to be denied. At the end of the day, the government still establishes a little bit of a roadmap here of what is going to be adjudicated and what isn't going to be adjudicated, what's going to be approved or not approved. It goes back to that framework, everyone, right? Are people going to be approved because they have extenuating circumstances or extraordinary circumstances? Yes. If you're here also on a dual intent visa and you're able to prove that merit behind why you deserve that green card, then yes, there's still going to be approvals. But I will say that we need to wait very strongly until these guidances roll out. For many of you who might be joining right now, who are new to the stream, I'm going to reiterate this kind of pretty repetitively, and I think it's important. The guidance, or like this memo that came out, this policy memorandum, right, to me is very much just a generality, right? Like I think it's like a lot of words and a lot of kind of impression of like, hey, right, we're just also stating that there's this discretionary authority that USCIS and these officers technically always had, right, when it comes to adjudicating adjustments of status, right? They're introducing kind of an interpretation based on the case law and the guidances so far that's saying that, number one, if you came here on a single intent visa, right, you need to have some level of extraordinary circumstance that's explaining why you're not doing a consular process instead of an adjustment of status. The second thing that is also coming out of this, in my point of view, that I think is a big footnote for many of you who are even applying under dual intent, is another reminder to the officers that even if you have a dual intent visa that gives you coverage on the whole extraordinary circumstances for the adjustment, right, that requires you not to go to your home country, it goes back to why do you even qualify for this green card, right? It's no longer enough to say, I've proven my eligibility based on the I-140 filing. I did the EB-1A, it got approved, right? I've proven that point. It goes back into the fact that it is possible that on a practical level, if you get invited to an interview or during even the initial filing process, then you need to include the argument again about why you have this merit, right? Why is it that you are someone who is deserving of this green card, really showing your feathers of positivity or positive equities in the whole process. Right now, going into the next question. Oh, thank you so much. I do appreciate the words of appreciation from many of you here. I'm trying my best to answer as many questions as quickly as possible. Right. I had an AOS filed on EB1C with a valid H1B, had an interview on April 29th. Can this impact me, right? I have to reiterate kind of the two perspective opinions here when it comes to pending AOS applications. On my personal note, I do find it kind of difficult to understand if the government decides to apply this, what we call retroactively, for cases that were already filed prior to this memorandum, or for cases even were filed like years ago. Because to me, it opens them up, or it makes it more ripe for someone to litigate, right? Because it's like, well, I didn't know about this. I didn't know that they were going to be kind of demanding this interpretation or this argument that's involved, right? The second thing that I will also say for every single one of you that's here is that the other interpretation, and this is what came out from earlier, we had Mike Valverde, a former USCIS executive, here kind of explaining his thoughts, all right, based on his experience in that position in running kind of the field operations for the government, is like the perspective that he held is that, yeah, under this administration, it's possible that they have this tolerance for that litigation, right? That they're ready to kind of implement and operationalize something that's pretty strong, and then they're going to take in all the punches that are going to come in their way to see what sticks and what doesn't stick, right? So I think it's kind of up in the air. I think for myself, it's like I tend to have this maybe a little bit of a positive disposition, right? At the end of the day, we really don't know until we know, and there's not really a sense of panic. I think from the lawyer side of my brain, it's like, wow, there's a lot here for people to unearth and litigate about. Does this affect already approved AOS and future I-751s? I think it's less likely to impact somebody who already has the approved green card, right? Now, 751s are not adjustments of statuses. I want to be very, very clear about that. Remember that this memo is specifically to the 485 process here. It does not reflect on the other kind of things that could be what I call AOS adjacent. Like some people here were asking, does this impact my ability to get that EAD card? A 765 is a different form from an adjustment. A 751 is that removal of conditions that happens after you do maybe like a marriage case where you are starting with the 2-year green card and now you're removing it so that you can have the full 10-year green card. So I think that in this case, it's a little bit of a lower risk, but it doesn't hurt for you to kind of keep an eye on the ball, make sure that you're staying up to date, primarily because there's a lot that's in flux right now and can change very quickly over the weekend and into the next week and even to the next month, right? I see here, is it safe to travel on advanced parole? So I think one of my perspectives, like even before this memorandum, like when I think about advanced parole, I always think to myself that it's a little bit discretionary. Like if I had to look at the language, it says may, right? May enter you back into the country without abandoning your status. And may can have a lot of interpretation. So under a tumultuous time when there's a lot of changes happening in immigration, I try to advise a lot of people to focus on non-essential travel versus essential travel. right? If it's non-essential, try to stay in the United States, because at the end of the day, what is the most defensible position is always being in the US and not being out of it, right? Valverde had a good point about this. At USCIS, if they want to deny you based on all of these grounds and all these things right now that's going on, they have to say it. They have to write it down in written word about what the grounds of the denial are. At the consular level, it's very different. It's very, very different. There isn't really like a rebuttal mechanism, right? There isn't a way for you to kind of counter argue. At USCIS, there is like this methodology of they need to tell you why, and they need to give you kind of the opportunity to rebut, potentially through a motion and all the different scenarios that could play out in that process, right? Will officers hold on adjudicating cases till USCIS rolls out guidance for each case type? That's not really clear right now, right? There's not really, like, everything just kind of dropped, right? Everything is relatively new. So the question becomes like, how is this going to play out? Valverde, who was here earlier, our former USCIS executive that's out there giving us really great insights, is saying that, well, it's kind of hard to figure out how to operationalize all of this, right? He used to be in the position for being that voice of going to the field offices and saying like, hey, right, this is kind of how these things need to be played out, what kinds of training needs to occur. The question of whether or not it's going to hold, the government hasn't said, right? I really think that it does depend a lot of when we see these guidances come out. I think what history has shown is that it's potentially true that there could be rescheduling. It is also potentially true that they'll let the interviews play out, right? But they might ask for more time to review the application, or they just don't have the authority immediately to approve the application. Kind of a la like the social media vetting kind of components that played out for a lot of the H-1B, F-1, and J-1 scenarios, right? Going next. Let's see here. There's just a lot of questions coming in. I'm trying to make sure that we get to a lot of like the really juicy ones that's most helpful for the wider crowd, right? Just wondering what it's going to be like for people who have pending 751s from a banned country, along with the re-vetting of Biden-era green cards. All right, so I'm going to break this down. 751s are not the same as adjustment of statuses, right? I really think that the focal point of this memo has been the adjustment of status, or the 485 process, right? The question of how the banned countries kind of work alongside a lot of this, along with the re-vetting of the Biden-era green cards, I think these are kind of like separate boxes, right? We have seen a lot of litigation related to the visa bans, related to the immigrant processing pauses, right? I think you need to kind of keep your eye on the ball there, because there have been some successful litigation when it comes to some of the immigrant pause related ones. I think for those of you that are thinking about the re-vetting, right? I think there was like this whole announcement about how the government's kind of like reopening and re-looking at these cases. I think since then, we've seen maybe some elements of this materialize, but again, it's still very unclear if, you know, to what extent that's happening. But keep your eye on the ball, Luke. I think my perspective here is that 751s are not part of this memo per se, but if you are impacted by the banned countries, then I think that is a separate conversation, and you need to be reviewing a lot of the updates related to existing litigation on that part. And a reminder that some of these bans are not really bans, they're like pauses, right? Let's see here. Okay, so I think this is a common question here. Does this affect NIW? It affects not necessarily the I-140 petition, right? There's two parts to a green card process. You have the I-140 that proves your eligibility. Guys, you guys could still apply for the I-140. You can still apply for the argument for why you're an individual of extraordinary ability, why you are doing something that is of national interest, or maybe going through your perm processes. What you need to be conscious of is actually the step thereafter, which is the adjustment of status, right? If you decide to do an adjustment here in the US, be extremely mindful of the visa status that you are in, right? Really seek counsel early on, especially on how you actually apply the I-140. That's what's actually important during the early process when you're applying for an NIW, is what boxes are you checking? Are you checking the consular processing box? Or are you checking the adjustment of status box, right? That is a careful consideration now whenever we're moving forward with a lot of these cases. And I think for adjustment of status, right, even if you have an NIW, it's not an automatic provision. I think where a lot of people are conflating ideas is that the government is now asking for a level of merit. Like, why do you qualify for this green card? Why do you deserve this green card? And a lot of people who have NIWs are like, well, I'm already doing something of national interest. That's by virtue of it going to be the main argument. There are elements to that that can be helpful to the argument, but you need to make the argument and be prepared for it in the filing, and especially at the interview. Really good counsel will be preparing preparing you for some of these questions that are upcoming. Okay, can elaborate on EB1 I-140s. Will they be treated any different compared to EB2? EB1 itself is shorter, so does that stand a good case to argue? So the memo doesn't really talk about the different case types, right? They don't talk a lot about the different bases that people have when it comes to why they're able to adjust status, right? But the way that I'm interpreting this memo is that it doesn't really matter, right? It doesn't matter that you got it from an EB1A, EB1C, EB2 NIW, EB3, EB4, or even EB5, right? What matters is really two facets, right? When you file for the case, are you on a single intent visa, and you have to prove this level of extraordinary circumstances for why you are adjusting status instead of doing the consular process? Because at some point you affirm to the government that, hey, right, I'm going to leave the country. I'm not trying to permanently immigrate to the US. So be careful and consider this very strongly. The second thing that I would also note to you is that when it comes to the EB1 itself being extraordinary, it goes back to what I said earlier on the NIW. There are parts of it that can be helpful for an argument to show why you merit the green card, but it and of itself is not an automatic approval of you are granted this green card moving forward. So it's all about preparation and those key details in that filing for the 485, but also for a potential interview that you have in the future related to that adjustment, right? Please talk about TN. Been here on TN since 2015. My current TN is valid until May 2027. I have a pending 485 with my current employer. I'm also a Schedule A shortage employee. That's an interesting one, right? So for many of you who are joining the call right now, letting you guys know that we are answering questions related to this update that the government released, this policy memo regarding, I'm trying to like label it appropriately, but I think it's really like this standard, right? They're essentially saying that you need to be able to say that, one, you deserve the green card, right? Regardless of like the basis. And second to that, it's like this question of discretionary authority, which is that the officer has always had this discretion to make a judgment call on whether or not you need to be doing an adjustment of status, because the default state should have been consular processing. So TN is interesting, right? I want to remind again, every one of you, a TN is not a dual intent visa. It is a single intent visa. You're supposed to have the intention to leave the country at the end of your stay when you're on a TN, right? And the way that the government has been looking at this, it seems, based on this memo, is this potential kind of interpretation that, okay, tell me like the circumstances as to why you're seeking an adjustment of status instead, right? What are like the positive equities that are related to that? And then when you're saying that you have a pending 485 and it's through your employer, was it an NIW that they sponsored? Was it through a perm process, right? I think there's also an element to this where you're also going to have to explain, why do you qualify, right? What, not necessarily because you did all the right things and all the right steps to qualify for the perm, right? But what is really like that benefit, like why you deserve, why do you merit having this green card in the US? And it talks again on positive equities, like what are the positive benefits, right? What is the positive side of you being here than not being here, right? So I think that's one way to kind of really think about it, right? Any idea when we can have more clarity about the enforcement and caveats for this memo? That's a really good question. The one thing that I will say is that I look back to the 100K fee, right? The 100K fee was like a big seismic policy shift. And I will tell a lot of you that I'm not necessarily interpreting this the same way as how big of a change the 100K fee was. But there was a lot of guidances that came out over that weekend after September 19th into the following week. It is really possible that it'll follow the same timeline, that a lot of the officers are really now working on kind of rolling out and operationalizing it. The government has hinted in this memo, like the rollout of guidances on case types and scenarios, maybe through USCIS FAQs or really formal guidance or updates to the policy manual, right? I think it's hard to say, but I will say I am anticipating a lot of information in the next week or the following week thereafter, at least within the month. I really think that the reason for a lot of this is maybe there's a lot of pressure from a lot of companies that maybe have direct relationships that they're pressing upon, being like, we really need more guidance on this because we have a lot of staff here who are on work visas and we just want to make sure we're doing the right thing. And I also think that there's a lot of maybe reporters out there maybe asking these questions a lot, but I do think that there is things that are probably going to be coming out. Let's see here. How might this affect DV lottery winners who are undergoing AOS, especially if they're on single intent visas like an F1? I mean, the reality is that you filed an adjustment still based on a single intent visa. I think it's one thing to consider. A lot of DV enrollees also win abroad. So it goes back to that memo question of, why is it that you opted for an adjustment of status instead of consular processing, and being able to articulate that to an officer, right, in order to explain the extraordinary circumstances that they're requiring based on this memo, right, for why you can't go home and finish off the process abroad rather than here in the United States. But I can't even tell you what that definition of extraordinary circumstances is. And then moving on from that, I think it goes back to merit, right? I am kind of curious about what the government will think about for merit for winning a lottery, right? But I will say that I think it goes back to like the positive equities, right? What is like the good that you're bringing here to the American public and to the United States, and thinking very clearly with your counsel who was involved in the filing of this process of what are like the positive equities that you can show. For many of you who might be legal nerds out there, I think the way that I interpreted it for myself as I saw this coming out is, imagine I'm trying to make a 212 argument when I don't necessarily need to make a 212 argument. It's like I have to be able to argue like what is the positive side that outweighs the potential negative factors that the government is looking at. So if the negative factor is that, hey, you came in on a single intent visa, but the positive factor is you built a company that has hired 20 Americans, right? Like it seems to kind of like outweigh the negative factor there potentially, right? So that's one way to really think about it. Let's see here. This is a good one. Hi, is this policy actually law, or is it discretionary that can be challenged in court? And also, is it bait for it to be litigated so it can go to the Supreme Court and be affirmed there, right? Gonna put my hands up here very quickly as a reminder to everyone. I am not a federal litigator, right? But I will tell you what I've seen in immigration thus far, right? Is the policy actually law? The answer is no, right? It's really memorialization of what was actually case law. I think when I first read this memo, my kind of thought was like, well, that Supreme Court case that they're referencing in the memo, that was decided already. We knew that that was part of it, even though my perspective was that it was a narrow finding. Valverde made this very clear. The circumstances of that case was very much someone who did overstay, who did make willful misrepresentations to the government. So when a lot of those things were happening, my perspective was like, all right, that's specific to a really bad scenario, right? So when they decided to expand it on this memo, it's kind of interesting. I think it's like a declaration of interpretation and how the officers are going to use it. And yeah, it can be challenged in court. I think, you know, it depends on how you read it. I think when we had Mr. Valverde, Mike earlier here, who was a former USCIS executive, I think the general consensus, whether it was myself and with him and the wider kind of practitioners that I work with in the field, a lot of it was that we do think that there's going to be challenges. There's a lot of room for challenges in the court here, because it's like, what does extraordinary circumstances even mean, right? Until we get that information, like, is that like a new standard? Where is that being established from? What is like the framework, right? Is this leading to more pauses? Is it going to be retroactive? Is it going to be into the future? We have no idea at this time. It's not very clear. So I think it's something to be mindful of. And is it bait? That's a good question. I don't really know. I think that it should be in many ways something that people are very mindful of. But I do think no matter what, whether we think it's bait or not, there's going to be room for litigation here, right? I think there's a good question here. I have international travel planned tomorrow. Is travel not advised right now, even of valid dual intent visas, right? This is a good question. I think it's taking a step back, right? A lot of my guidance when I'm being extremely conservative has always been think about essential travel and non-essential travel. At the end of the day, a dual intent visa has a lot of really great provisions in it, which is that even if you had this pending I-140 to 45, travel is something that is kind of built in as a little bit of a protection. But I will say, remember that the safest position to always be in, especially when it comes to government changes, immigration, any tumultuous environment, is to be in the US and not outside of the US. It is the most defensible position to be in the United States, right? And I think I have a couple more questions here that I'm going to kind of look at. I am a physician working on a pending 485. Will I be an extraordinary case? It's hard to say. I actually don't know even the basis of your 485, right? I think what you're probably referencing is there was a lot of news articles where they even unpaused cases for physicians from the paused countries, some of the banned countries here, right? I think there was like a framework that's being adapted for that. I have no idea if they're going to provide exemptions for physicians, but the one thing that I will say is that when I'm looking at this memo, right, what I can perceive is that if you're able to make an argument for extraordinary circumstances, let's say you're here on an F1 or a J1, right? Why are you staying? And there's a good argument for that. And separately, like the merit that's involved, which is that the reason why I'm a good person is because I'm working as a physician in a rural, underserved community. Maybe that's grounds for it. But I can't even affirm any of these things. I want to make it very clear because the definitions are not really there, right? I think when I'm looking at this memo, I'm thinking about many different ideas of how I, as an attorney, would advocate for my clients and be able to tell them what to make an argument for. But we will not necessarily know exactly what we're looking for until those guidances come out. And the government has really hinted at that. The memo really says like, hey, we're going to push out some guidance about specific case types and we'll go from there, right? All right, so I think we're leaning into some of like the last questions that I'm going to be looking at so far. I've been kind of live for a while, but please be sure to follow us on social media because we have a lot of upcoming content and a lot of maybe other webinars that are coming out related to this subject. And please keep apprised because as we get more guidances, I can foresee myself being put on this live stream again, along with many of our colleagues that are in the industry. So please be mindful of that, right? Is this policy, can it affect if someone wants to go from the O1 to the EB1A? Yes, right? Because I want to remember and remind everyone here that there's two parts to every green card process, right? You have proving your eligibility for the green card. That's usually the I-140 process for employment-based. For EB1, that's the case. For marriage cases, family-based cases, that's the I-130. For a lot of the other cases that are out there, could be like an I-360, but usually there's a form that you file to prove your eligibility. The second part of the process is whether or not you choose to adjust status here in the United States, where you're asking the government, please change my status or adjust my status from whatever it is that I am here on into a different status in which is the green card, right? That's where they do the medical checks, the background checks, and the like. But kind of second to that, I will say that you can also opt to do consular processing, where you finish off that green card process abroad, which is really what this memo is talking about, which is the default state should be going to the consular process, especially if you're on a single intent visa. And the O1 is in this weird gray area. It's what I call pseudo dual intent. The FAM, or the Foreign Adjudicators Manuals, things related to the Department of State, tries to kind of say that it's a dual intent visa, but the O1 is a little bit different domestically here in the US because it doesn't have the same protections as an H-1B or an L-1, where you could leave the country during the pendency of an adjustment and not abandon the application. So I think that's also an area that requires clarity from the government, is how are you going to be treating O1 applicants during this process who are in this kind of weird gray zone, where they haven't necessarily been punished in the past for filing adjustments. People have been able to renew O1s and extend their O1s even during the pendency of a lot of their applications. Even with the approved I-140 and the pending AOSs, what is that going to look like moving forward? It's hard to really say. But remember, guys, that O1s are not true dual intent visas. I want you guys to remember that. I'm still going to kind of do as many questions as I can before I start running out of steam, just to let you guys know I'm recovering from the flu, trying my best here, because I think you guys deserve to get some acknowledgement of some of your questions here. Hi, I'm currently in H-1B status. Although my last admission to the US was on F1 status, I have my green card interview scheduled, right? So I think it goes back to like, how long ago, what are the circumstances? Because I think one thing to remember, guys, is that this memo doesn't just adjudicate, in my point of view, just what you recently did, right? If there was ever a status gap in your past, they're allowed to kind of unearth it and ask you questions. And a key example that I'm thinking about is there's a lot of situations where people might have overstayed on an F1, because there's something known as duration of status, right? Where if you overstay on an F1, even if you're on unlawful status, you don't necessarily accrue unlawful presence, not immediately. So in those situations where you haven't accrued unlawful presence and you even overstayed by 2 years, right, the government doesn't actually put an inadmissibility bar, or they don't render you inadmissible because of that overstay. There are rules about when unlawful presence does kick in for an F1, but I want you to keep that scenario in mind. That F1 student leaves the United States, they won the H-1B lottery, and then they applied for the H-1B. They got the visa stamp because there's not really grounds to deny that person. They don't have an inadmissibility factor. Maybe they were under an administration that was much kinder to those adjudications, and they were able to come back on that H-1B. In that scenario where they're now seeking an adjustment, it does raise a question when they're looking at the positive equities. Hey, man, you overstayed your F1 for 2 years in the past, right? You got to explain to me, like, this whole situation. I think of that as a negative impact. How is that going to look for me moving forward? So I really think that when you have someone who's here already on H-1B status, take a step back. It's not good enough for you to be a dual intent. You need to really think about immigration history. And that's the reason why my call out to every one of you is not only should you be waiting for more guidance because this memo is not really clear on the application, the operations, and the kind of questions that immigration is going to be asking, it's also not necessarily clear in my perspective, right? That, you know, how far back are they looking at? You need to be really mindful of your case history, right? Talking to the person who's been helping you with this application, who knows your circumstances and how they would counter argue it. So keep that in mind. You really should be, especially in this time when there's a lot of room for interpretation. That's when a lot of people who have studied and lived and breathed immigration should be the best people that you'd be talking to. All right, so I see here, any restrictions based on this memo to do with change of status from F1 to H-1B? Common question that we've been getting. Remember that this whole memo has everything to do with an adjustment of status, a 485 process, right? It has no conversation here about changing your status from an F1 to an H-1B, to an H-1B to an O1, right? It's not about the non-immigrant process. It's about the 485, that adjustment of status, right? But don't just limit to your thought process on the 485. When you're filing the I-140, I want to remind all of you that there's a box that you have to check. You have to decide between filing this as a consular process case in the future, or if you're going to be seeking an adjustment of status. That is a key strategy question now when I'm looking at this memo, especially when the guidances roll out. Be extremely considerate about that selection. Because one thing that I did flag in my earlier conversation, and I want to flag to all of you who are in the middle of deciding to file an I-140 or not, right? Traditionally, when you select USCIS, the case stays with USCIS until the point that you do the adjustment, right? But if you select consular processing, it gets moved to the National Visa Center, and they essentially open a case with the Department of State. It's called a DS-260. They start collecting a lot of information from you guys in order to get to that interview stage later on, right? Now, the problem, and that's what I raised with that former USCIS executive, Mike, is that if you select adjustment and then later on decide to do consular, there's usually another form that we have to file to transfer your case from USCIS to that NVC. And it's not a premium process, guys. It can take a year, right, before NVC actually receives that case and opens it up for consular processing. The reverse is not true, weirdly enough. If you select consular processing, the USCIS can still adjudicate that 485 later on down the line. But I digress. It's a strategy question. It's also one that requires a lot of legitimacy. And guys, do not lie to the government for strategy purposes. You need to be very careful about your intention and that it is a realistic and the decision that you are going to be making. This is the arena of compliance. It's not just about strategy. It's about making sure that you are telling them what your honest thoughts and your truths are, because I do think it's going to be very punishing if you decide to say something else than you really intend to mean without at least a solid argument about the extraordinary circumstances that made you change your mind, right? So I really want you guys to really think about that through. Okay, so I will say that we're coming up to probably close to the conclusion. I'm still going to answer maybe like one or two more questions here, right? Because I see a lot of good ones here. Hi, I am a citizen and I filed a 485 for my husband who's from India, have a biometric appointment scheduled for him. Why should we be our concern for this memo, right? I think the question becomes your husband, what status were they in when you applied for that adjustment of status? I assume that this is a marriage-based case, right? It's not really necessarily the question of the legitimacy of the marriage, right? In this particular scenario, what we are seeing is that the government is questioning why can't your husband consular process that case instead instead of the adjustment of status. What the memo declares is that the default state should be finishing out the process abroad, especially in the circumstance where they're here on a single intent visa, right? So I really think it's something to really be considerate of, right? If that basis was a single intent basis and not a dual intent basis, that's what I would be considering at this moment. I see here impact on long-term H-1B couple trying to file EB-5, right? I think H-1Bs are dual intent visas and there's some protections in there. However, take a look at your immigration case history. Was there ever a time that you overstayed, status lapse, anything to kind of keep in mind here? The basis doesn't really change what the government is scrutinizing, right? If you are doing an EB-5, it doesn't change the fact that the officer says, we get it, that you filled the technical requirements, you made the investment, etc. You could have even gotten the actual underlying basis approved here. I think it's called an 824. Like I'll have to remind me like the name of the form for the approval for the EB-5, right? However, when you do file that adjustment, they will still say, what is like the merit? Why do you deserve having the green card, right? There needs to be some sort of substantial benefit, and it's not enough to just say I invested money, right? Show like, at least when I prepare people for adjustment interviews, I always say, think about all of the good things that you brought to the United States or what you can bring to the table here, right? Is it that you started a business that hired 20 Americans, right? Is it that you are building something innovative that can help the United States remain competitive? There's a lot of things that you need to be thinking about when you're trying to express to the office the merit behind your green card case, right? I think just as a general kind of like good note for every single one of you, because I think this question really encapsulates it, right? Hey, I've been super compliant the entire time. I'm on a dual intent visa, filing the 485. Is this going to affect us, even though it's an immediate relative that has what we call 245C protections, where even if there was a status violation or a lapse, there's family reunification policies that mean that we're going to keep together and they're going to overlook it. Guys, the way that I think about it is that this memo is essentially for anyone who's filing an adjustment of status, but I also don't want to scare you, right? There's not a lot of practical guidance that is behind this memo just yet, right? We don't actually know what specific guidances are out. I think they kind of like dropped this. There's going to be a lot of media discussion. There's a lot of discussion here that we're having right now about how it's going to be interpreted. But for those of you in even in what we call this golden triangle of like, hi, I have a dual intent, I've never had an issue, now I'm filing my 485 timely, what does this mean for me, right? I think you're probably in a better position than most, but it doesn't change the fact that the government can still ask that question, that all-time question of, well, can you tell me a little bit more about what makes you meritorious or why do you qualify for the green card, right? It's no longer just that technical basis. Well, I qualify because I'm married to a US citizen, or my child is 21 and over and is sponsoring me as a parent, as an immediate relative. Now it's like, what is the good parts? Like what makes me a good person? What is it that is kind of positive in equity, let's call it positive equities that mean that the government should favorably grant me this green card, right? Because look at the footnote in the memo. They said that, hey, it doesn't mean that you are given favorable discretion by virtue of you being on an H-1B or an L-1B. There still needs to be a relevant argument that's involved, right? So I think we're going to be wrapping up pretty soon. I think I'm going to give it like another 9 minutes. Let's cut it at 6:30 exactly. So I'm going to try to kind of answer a little bit more questions here, right? I see here, my wife is also in L1B, potentially looking for change to H1B. Is that switch going to be affected? Reminder to every single one of you guys, the whole entire memo focuses on adjustment of status. It doesn't impact the non-immigrant statuses where you're filing from the L1B to the H1B. This is focusing a lot on adjustment of status, which is the 485 for a green card, right? I think a lot of the times the reason why some people in the general public are getting confused is adjustment is essentially a synonym for changing, right? But a change of status is a different filing. In this case, for the L1B to the H1B, it would be an I-129. For this memo in particular, it's for the 485 or the adjustment of status process, where you're going from a status of some format into a green card. Going into more questions. So Again, no overstay, filed I-130-45 through a USC spouse during an H-1B grace period after layoff. Will the USCIS memo affect me, right? I think the way that I think about it is that H-1Bs have at least some level of grace to say like, hey, like, I don't need to necessarily explain the extraordinary circumstances related to why I'm adjusting because I'm technically allowed to adjust. However, we don't actually know the practical guidances of how they're going to apply this on a per visa category or per basis category, right? I think for a lot of people on H-1B and L-1s, I would tell them take a step back and think about your case history, right? When you entered on the F-1, did you say anything crazy? Did you overstay? Was there a physical presence issue? I think a lot of people during COVID, right, may have accidentally overstayed on their ESTAs, even if ultimately they were granted a way to come back because there was a good reason. Like those things can come back to bite you in this part of the process. I think it's like a reminder again that the way that the memo has positioned adjustment of statuses is that this is a discretionary benefit. The officer does not have to grant you this approval, right? They're supposed to kind of really review holistically, right, the merit behind the case. Do you qualify for the green card, not just on a technical basis, but on a meritorious basis, right? Like what is like the good that comes from it? Valverde, who is a former USCIS executive, actually said it really, really well in an appointed way, which is that on practice, what we have seen is that in the interview, they just ask like, you know, tell me more about you, like what makes you a good person, right? Like show to me that, you know, you've been doing like good things for the United States. And that has come up in certain interview contexts, even in the I-134-85 process. So be prepared, be prepped appropriately for these types of cases, right? Think one more question here that I'm seeing here. TNs, right, to EB2, is that affected, or TN when you marry a citizen, do you have to leave and go back to Canada and wait? Okay, there's no like have tos in these memos. Like there isn't like anything that's forcing you to file for consular processing. What the government is really holding up is like a warning sign or a caution label, right? Which is that the reality is that they're most concerned about individuals coming in on single intent visas or certain types of statuses that aren't supposed to be permanent. They're supposed to be temporary. You're supposed to have the intention to leave at the end of that stay, right? And the TN is a single intent visa. But don't panic just yet because the government has not rolled out practical guidance about the different visa types and how they're going to be operationalizing this, the kinds of arguments that we need to be making, even the definition of extraordinary circumstances that would allow someone to do the adjustment instead of consular processing, right? But if you are someone who's on a single intent visa and you're filing for this kind of adjustment process, this is where I'm going to tell you, you really need to talk to an attorney, right? You really need to really think about this deeply and make the right judgment calls and the right arguments before you opt to file the case, right? That is extremely critical and important. Use the time frame that you have remaining before filing to make those judgments. Okay, right. All right, so I think just in these last 5 minutes, do you think dual intents like the L1 will be affected? Guys, there's a specific footnote about H-1Bs and L1s in the memo, right? I think the effect is a little bit different compared to the single intent visas, and I want people to be extremely mindful of that. My perspective here so far, when I'm looking at the memo, I think it really just taking a step back. Remember your case history. It's not just about the L1, right? It's about everything leading up to the L1, right? Did you have an overstay on an F1 at one point? Did you overstay an ESTA at some point, right? I really think that the way that it's going to impact maybe people who have no overstay, no status issues, and they're filing from an L1 to this green card process is the question of that merit behind the green card, right? It's not just the technical requirements. Well, here I got the EB1C, I'm a multinational executive, I met the technical requirements. It's what is kind of the good moral character, or what is the good that you are bringing to the United States, right? Remember that the way that they're framing this memo is that it is a discretionary finding to allow these adjustment of statuses. And then going into, will it impact the marriage-based case for a green card? Yes, right? The reality is that, remember that what is being impacted here is the adjustment of status filing. And a lot of the analysis that attorneys are really doing is like, what was the, let's call it, current status that you are in when you are going to be filing for that adjustment of status. Are you on a single intent visa or a dual intent visa? Separately, like what are the positive equities that we can argue for that show the good? The way that I think about it is like a balancing scale. On the left side, if you had a previous overstay or you are currently overstaying a visa, right, that's a negative factor that's already pushing down on the scale. I have to think about all the positive things that kind of even it out, that say like, hey, this is the reason why they should maybe overlook these negative factors for the positive factors that you're bringing to the United States. So I really think that that's one thing to really, really consider, right? So talking to the attorneys, right? I know that some people might come to me saying that, hey, you're a little bit biased. You're an attorney yourself. You're involved with a law firm. You have every right to or consideration to say that you need to be talking to an attorney. The reality is that I'm really only saying this because I am somebody who is quite concerned about making sure that you write and say the same, like the right things that are realistic, that are truly your intentions when it comes to these applications. I don't want you to do missteps. And I also don't want people to make the mistake of potentially lying to the government or potentially saying things just because they're trying to avoid something, right? I think this is truly a question of not only case strategy, but one about being able to avoid concepts of willful misrepresentation, being able to put together the right arguments once we're able to at least be told by the government what they're looking for the definition of extraordinary circumstances, and then separately, what makes you merit the green card, right? I think, like, in closing notes, because we don't have like these last few minutes, I want every single one of you not to go away from this call panicked, right? There's going to be a lot of panic in the air, but I want to harken back to the 100K fee. A lot is going to change between now and next week. The first impression that a lot of us attorneys had when we were looking at this memo is like, I mean, we kind of knew that the case law was out there, that the government was already looking at good moral character for a lot of these 485 applications and the like, right? So it's like, what else is there? Because we had already been prepping a lot of our clients for those questions if they do go to an adjustment interview for what makes them like positive, right? Like what is their positive equities, we call it, right? And I think what takes this a little bit of a step further and why we're kind of hesitant to say that this is like a big issue is like this concept of extraordinary circumstances is kind of confusing, right? We actually don't know the definition. We don't really know exactly what the government is looking for. And we're looking into these guidances that are going to be coming out essentially pretty shortly, according to like the way that the memo is written, but who knows, it could be a week, 2 weeks, 3 weeks, right? So before people hit the panic button, I really think we should be very mindful of the fact that the memo is not clear. The government understands to some degree that they need to provide clarifications because they even noted it in the memos that they are going to be pushing out guidance on this. Policy manuals have not been updated just yet. And earlier, if you were here for this particular live Q&A section or town hall, what ended up happening is we had a special guest, Michael Valverde, who is a former USCIS executive, who was the associate director of field operations, who basically said that in his position, if something like this came out during the time that he was working and overseeing the field operations, he wouldn't even know where to begin, right? Like, where do I begin? There's just a lot of like things that are part of this memo, and how do we kind of roll this out? But guys, it is 6:30. I've been live for closer to 2 hours now. I really hope that some of you got the insights. And I know some people are saying, I'm panicking. What do I do, right? The reality is that, guys, we've seen a lot of this before. And what I mean by that is, remember that 100K fee. It started with annual fees, guys. If any of you are on an H-1B, every single year you're going to be paying 100K for it, right? And then it went into any new renewal, any new case, 100K fee everywhere, right? We're going to tax and bill this to the companies, right? And then you kind of move forward another couple weeks, and then like all these guidances kind of came out and said, oh, it doesn't apply to this person. It doesn't apply to that person. It doesn't apply to anybody. All the way to the point where today, I want to give you guys some really solid statistics here. Apparently only 80 people have paid the 100K fee so far, guys. That's $8 million total, all right? 80 people. So when you're thinking about like these seismic shifts that the government has kind of rolled out so far, I think it's very much, instead of panicking immediately, getting on the rowboats, getting onto like the roller coaster ride of kind of making judgment calls. Please do not make panicked judgment calls and like shooting from the hip. There's a lot here to unpack. There is a lot of ripeness to litigation that is involved here. So please, guys, be very mindful of that. Us, the attorneys, I don't think we're really panicking just yet. And a lot of our clients have been very much counseled to say like, hey, we really need to wait and see until these guidances come out, right? But I think this is like a redress of the existing case law and the guidances that were already out there. I think we're going to see a lot more in the next few weeks. Please keep following us on social media and all the ways that you found out about this particular live Q&A session. I really think that we're probably going to do another live stream and another town hall the moment that more information breaks out. Big thing that I also want to note before we head off is that social media is a different ballgame, right? If you guys see tweets, whether it's from DHS or a lot of different spokespeople that are out there, remember that the way that I look at it is that wait until the memo, wait until the memorialization, wait until the guidance, right? Please think back to the 100K lottery, the 100K fee time, right? A lot changed very quickly on who gets impacted and who doesn't get impacted, right? And please, 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 talk to your counsel, talk to the people who helped you with these filings, right? The reality is that the way that it's going to impact you and the way that it's going to be dealt with is very much fundamental to your case, your immigration history and the like, right? And by the way, I see a lot of questions regarding exemptions. I think my perspective here is that no, they haven't really said what their exemptions are. A lot of the times they go under the extraordinary circumstances scenario. And I think that that's a question that's out there for people to see, right? But thank you guys so much. I hope that you guys learned as much as you could. I know that I couldn't get to every single question that was out there in the moon, right? Please do follow our social media, follow a lot of our postings. We did put together a really solid blog post on like these news. I think like a lot of practitioners out there are also providing their commentary. This is really a developing story. So as more things kind of come out and more information comes out, I think a lot of us are going to be able to share that insight. But thank you so much for joining. And hopefully, I hope like this conversation today was very helpful. Thanks, guys. Thank you.